Hi everyone, and welcome to our webinar on ending employment, understanding your obligations as an employer. Now, my name is Sophie Joselyn. I'm a senior lawyer in LegalVision's employment team, and I'm joined today by my colleague Joel Hayden, who is a practice leader in our team. Now, before we jump into things, we would like to start with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present, and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us from today. Now, before we begin, we just wanted to run through a couple of quick housekeeping items, which are set out here on the slide. Now, at the end of this webinar, you will all be emailed a copy of this recording, so no need to be frantically jotting down notes as Joel and I are speaking. Please also feel free to submit any questions that you have relating to anything that we've discussed today in the chat box that's available to you as well, and we'll try and get through as many of those at the end of the session. And finally, we do ask, if possible, that you can please complete the survey that we've got for you after the webinar. Any feedback that you guys can provide us is super useful for us in making these webinars as valuable as possible, so we really appreciate any feedback that you can pass along. Now, in terms of the agenda for today, we're going to be discussing a few topics relating to ending employment. So first of all, we're going to be looking at the circumstances as to when a termination may occur. Then we're going to be looking at what your obligations are as an employer prior to proceeding with the termination of your employee. Then we're going to take a look at what your obligations are upon termination, any risks that follow from termination, and then, as I mentioned, we will have a Q&A for you at the end so that we can address any questions that you may have. And then lastly, we are going to just briefly run through a special offer, which we do have for all attendees who are joining us on today's webinar at the end. So let's get straight into it then. Now, in terms of our first topic of when a termination might occur, there are a number of different ways that termination can occur. However, they are broadly broken down into the categories set out on the next couple of slides. Now, first of all, an employee can, of course, be dismissed at the employer's initiative. And that broadly means that the termination has been brought about by the employer and is not agreed to by their employee. Now, as we all know, there are a number of different reasons why an employer may want to bring an employment relationship to an end. It could be due to an employee's unsatisfactory performance, if the employee is failing to meet their KPIs, or just generally not meeting the expectations you have of them in their current role. It could also be for conduct reasons. So that could be something as simple as an employee's failure to comply with your lawful and reasonable management directions, to comply with your policies and procedures, for example. Or it could be something more serious, which could warrant summary dismissal for serious misconduct, such as an employee who's been engaging in things like theft, dishonesty, or even intoxication at work. Now, the other circumstance where an employer may be left with no other option but to dismiss an employee is where the employee is unable to perform the inherent requirements of their role. And this usually will come about where an employee suffers some sort of injury or illness, which really prevents them from carrying out what were previously inherent requirements of their pre-injury position. So this might occur, for example, if you've got, say, a person who's employed as a truck driver who then goes and suffers an injury which renders them no longer able to drive with or without reasonable adjustments. And that's where the type of situation would arise, where the employer would then need to ask that question as to whether or not the employee is actually still able to carry out the inherent requirements of their position, given that they're no longer able to drive. And then finally, we've got a termination on account of redundancy. Now, as we went through on our previous redundancy webinar, a termination on account of redundancy can be necessary where an employee's role is no longer required to be performed by anyone due to changes in the operational requirements of your business. So that typically might occur due to things like automation or even just a reduction in payroll costs due to a downturn in business, which necessitates a reduction in numbers. Now, turning to terminations at the employee's initiative, this commonly occurs by way of an employee tendering their resignation. Now, obviously, an employee may want to resign from their employment for any number of reasons. It could be, that they've got a new job offer. It could be a change in personal circumstances. But whatever the reason, a resignation will also effectively terminate the employment relationship. Now, one thing that's important to note when it comes to resignations is that in circumstances where an employee resigns but is forced to do so as a result of a course of conduct that's engaged in by their employer, this is what's known as a constructive dismissal. And that term, constructive dismissal, essentially means that the resignation was non-voluntary and was therefore brought about at the employer's initiative. So a typical example of a constructive dismissal would be a situation where an employer says to an employee, you either resign or you'll be sacked, because in that circumstance, the resignation has obviously not come of the employee's own volition, and they've effectively been backed into a corner where they've got no other option but to resign from their employment for fear of being terminated anyway. Now, finally, employment can also terminate in circumstances where an employee was only ever employed for a specific period of time via either a fixed or a maximum term contract, in which case the employment automatically comes to an end at the expiry of that period. Now, a termination due to the effluxation of time will not generally be considered a dismissal, as the employment simply terminates by the passing of time at the end of that specified period, and as such, again, this is not considered a termination at the initiative of the employer, and it's simply an automatic termination. Now, in terms of obligations prior to termination, I'll hand over to Joel, and he's going to walk you through exactly what the recommended process might be.
Thank you, Sophie, and good morning, everyone. Thank you for joining our webinar. And as Sophie has just outlined, the end of employment can be a result of either party's actions or by way of a fixed or maximum term contract completing. There are, of course, various levels of risk in these different circumstances, and the considerations prior to carrying out or confirming termination will necessarily vary. There's naturally more risk where an employer carries out the dismissal, as I'm sure you can all imagine, especially in relation to dismissals that relate to performance and conduct, because there is likely to be some conflict and disagreement around these matters. One of the key obligations to be aware of is compliance with the Fair Work Act in relation to what constitutes an unfair dismissal. An employee will have access to unfair dismissal where they have either completed their minimum employment period, which can be either 6 months for most employers or 12 months for a small business employer that has 14 or fewer employees, and where they have a wage lower than the high income threshold, which is currently $162,000, or where they're covered by a modern award or enterprise agreement. And that's a common trap we see regardless of the salary being paid to an individual. If they're covered by a modern award or enterprise agreement and they have completed their minimum employment period, they will have access to making an unfair dismissal application. Now, when we're considering the end of employment for an employee who has access to unfair dismissal, it is vital that the employee, either in circumstances relating to performance or conduct, ensure that they are proceeding on the basis of a valid reason and carrying out the process with procedural fairness, or in the circumstances of a redundancy, that they have established a genuine redundancy for the purposes of the Fair Work Act, which is a defence to an unfair dismissal application. Now, in that first example, identifying a valid reason is usually not too difficult, but this must relate to a sound and defensible reason that exists in reality, i.e. it can't be something made up or just a suspicion, it has to exist in reality. The more complicated aspect of this is often considering what constitutes procedural fairness in the circumstances, and this can be much more confusing for an employer. Fortunately, the Fair Work Act provides some guidance in relation to what will be fair in the circumstances, with some of the key considerations being whether the person was notified of the reason for their dismissal, whether the employee was given a chance to respond to that reason for dismissal, whether there was refusal of a support person during dismissal discussions, and whether warnings were provided in relation to the dismissal if it did relate to performance. And we can see on the slide now, and we're just going to head to that next slide, the relevant considerations in that second circumstance, which is where we're trying to establish a genuine redundancy for the purposes of the Fair Work Act. And the key criteria to hit here are that the employer must no longer require the employee's job to be performed by anyone, and that's the job differentiated from the person in the role, i.e. it's the job that the employer must not need performed by anyone anymore. The employer has complied with any obligations for consulting under a modern award or enterprise agreement, and this will usually require certain information to be provided to the employee or their representative in writing prior to a definite decision being made. And we also advise and suggest that even when an employee may not be covered by a modern award, it is still best practice to go through that process of consulting just to ensure the employee is not blindsided by the decision. And the employer also has to consider whether there are any reasonable options for redeployment within the employer or its group, i.e. the broader corporate group as well must be considered, and any options that are available for redeployment should be offered to the employee as part of that previously mentioned consultation. And so this brings us to the question of what is the position in relation to employees that do not have access to unfair dismissal, i.e. the ones who have the very high incomes above that threshold and that aren't covered by a modern award and also have not completed their minimum employment period. And this doesn't necessarily mean that an employer is allowed to terminate employment at will in a variety of unfair ways. The rule to follow is that the employer must ensure that the reason for the dismissal itself is not unlawful. And what this does is it largely removes the aspect of procedural fairness being relevant and means that an employer would simply need to ensure that the reason for dismissal itself is not rooted in unlawful discrimination or victimization under the terms of the Fair Work Act or discrimination legislation. And to illustrate an example of this, it would be lawful to dismiss an employee who does not have access to unfair dismissal for performance reasons. And there wouldn't be the necessity of undertaking a process of warnings or notice of performance issues prior to terminating their employment, as the employee does not have access to that unfair dismissal application. And another different scenario that Sophie's touched on as well is what to do when an employee is resigning. And in this scenario, it is vital for the employer to confirm acceptance of the resignation and ideally receive the resignation itself in writing from the employee. And this is to remove any doubt about whether an express resignation has been provided by the employee, as this is often a matter that can be put into dispute later by the employee, even retrospectively. And a relevant aspect of resignations that needs to be considered is that in some circumstances, an employer may need to be aware of the concept of a heat of the moment resignation. And this is where an employee has rushed their decision or is under pressure from other factors and provides that resignation. But in the circumstances, it hasn't really been provided with a true intention to resign, and it's more a rush of blood to the head. And in these circumstances, the prudent move for an employer to make would be to give that employee an opportunity to reconsider whether they do want to resign and follow up and seek further information as to the reason for this to occur. But of course, an employer is entitled to rely on an unambiguous resignation. So you would only need to confirm that decision to that extent with the employee. Now, I'll pass back to Sophie to address what obligations an employer has on termination, so following that actual action in dismissing the employee.
Thanks very much, Joel. And certainly not a straightforward process to go about a termination. So very important to get some advice. And then, of course, yes, we need to consider what exactly your obligations are. If you've done everything right, what we need to consider on termination. Now, broadly, the Fair Work Act provides that an employer must give an employee written notice of their termination on the day of termination, i.e. the date that the employment relationship ends. So for this reason, you should always ensure that you provide an employee with a termination letter confirming whether or not they are going to be required to work out any applicable notice period which may apply to their employment, and specifying when will be their last day of employment. Now, except for in circumstances of serious misconduct, such as where an employee is engaged in matters such as, fraud, dishonesty, theft, matters like that, employers are generally going to be required to provide notice of termination to employees in accordance with the national employment standards contained in the Fair Work Act. Now, you should also always check the employee's contract of employment and any applicable industrial instrument, such as a modern award or an enterprise agreement, to confirm the appropriate notice period which is required for your employees. Now, putting this into practice, essentially this means that as an employer, you cannot terminate an employee's employment unless you either allow them to work out their notice period or you elect to make the employee a payment in lieu of notice, which would need to be at least the amount that you would have otherwise been liable to pay the employee had their employment continued until the end of that notice period. Now, this might be relevant, for example, where you've got an employee who has access to commercially sensitive information, or you've just parted ways in not so amicable circumstances, and it may well be the case that you just rather remove them from the business sooner rather than later. So instead of having them work out their notice period, you would simply have them finish up effective immediately, and you would pay them in lieu. Now, along that same line, there may also be a requirement for your employee to give you a certain amount of minimum notice in circumstances where they resign from their employment. But you should always confirm their employment agreement or the applicable industrial instrument to confirm whether any minimum notice is payable in circumstances where an employee resigns. Now, in terms of final entitlements, obviously, we'll also need to ensure that you do pay out anything owing to your employee up until the date of termination when their employment comes to an end. And this will usually include payment for outstanding wages, as well as any accrued but unused annual leave, which they may have accrued up until the date of termination. Now, as I mentioned before, there may also be an obligation to make a payment in lieu of notice if you elect to have them finish up effective immediately. And there could also be long service leave entitlements owing. However, that will be governed by the relevant state or territory legislation based on where the employee is located. Now, one thing to note is that essentially unused personal carers leave will not be payable on termination. So even if your employee has quite a substantial personal carers leave or sick leave balance upon termination, that will not be payable, and it's effectively a use it or lose it policy when it comes to personal carers leave. Now, in circumstances where your employee is dismissed on account of redundancy, you may also be liable to pay redundancy pay, as per our last webinar on redundancies and restructuring. Now, the amount of redundancy pay that's owing will generally be based on an employee's length of continuous service with their employer. However, you should always check the National Employment Standards or any industry-specific redundancy scheme, which is set out in an applicable modern award, for confirmation of exactly what is payable to your employees in circumstances where they've been terminated on account of redundancy. Now, if your employee requests it, you would also be required to provide your employee with an employment separation certificate. And this is a template pro forma form which you can download from Services Australia. And essentially, it assists employees to apply for income support payments. In terms of other considerations, the only other matters that you would generally need to consider would be whether or not your employee has any other entitlements which need to be addressed on termination. So, for example, if your employee has vested options under an employee share option plan, then these will generally need to be sold at their fair market value or retained by the employee. And similarly, you should also check whether your employees are entitled to any kind of prorated bonus or commission payments upon termination, and this will obviously be governed by the scheme which sets out that entitlement. So that's it for entitlements flowing from termination, and now I'll hand back over to Joel to walk you through some of the key risks following a termination.
Thank you, Sophie. And I'm sure, as we can all imagine, this is the pointy end of things, and the end of employment is not always a happy time for the employee involved, and it can really be a difficult time for the employer as well. And that's especially in SMEs, where you probably as an owner have a day-to-day contact with the employee being affected. Australia is a jurisdiction that is quite protective towards employees, and the presence of employment-related tribunals such as the Fair Work Commission means that employees do have a fair amount of choice and access to making claims against their former employers, regardless of how the relationship ended or whether or not they do seek legal representation for themselves. And the claims that are available to an employee can be split broadly into two categories, and those that relate to the dismissal itself and those that do not, and really concern some other remainder of the employment relationship. To address the first limb first, the most common dismissal-related claims are the previously noted unfair dismissal application, a general protections application under the Fair Work Act asserting unlawful dismissal, and discrimination claims under the various state and federal legislation. Unfair dismissal and general protections applications are by far the most popular claims to be made by an employee, with around 18,000 of them being filed collectively a year, and around 13,000 of those are unfair dismissals. As briefly addressed earlier, an unfair dismissal application is concerned with whether the employee was dismissed for a valid reason and with procedural fairness surrounding the process. If an employee successfully establishes that they were unfairly dismissed, remedies available include reinstatement with back pay, compensation up to 26 weeks worth of their pay, and various orders in between. And it is more likely that compensation will be ordered than reinstatement will be, although reinstatement does occur from time to time, so it is a real risk. The employee has 21 days from the date of their dismissal to make an application, and this can be extended by the Fair Work Commission on application, and it only costs around $70 to do so, which can also be waived by the Commission, so very easy to access for an employee. Rather than this focus on procedural fairness, general protections and discrimination proceedings are usually concerned with the reason for the dismissal rather than the fairness in the process. Similar application fees to unfair dismissal mean that these are very attractive jurisdictions to employees with the potential for uncapped compensation to be awarded to the employee. And these types of claims can also include liability and the imposition of civil penalties for knowingly involved parties, which commonly extends to directors, HR managers, other leadership positions that are in a position to make decisions in relation to an employee's employment. And it's really common where an employee does not have access to unfair dismissal, whether or not they have a legitimate basis for a general protections or discrimination claim, they may shoehorn their claim into that jurisdiction, as there's no minimum employment period applicable for these types of claims, i.e. from the first day of employment, and even sometimes as a prospective employee, individuals do have access to make these claims immediately. And this is further compounded by the fact that, subject to certain exceptions, employment claims generally operate in a no-cost jurisdiction as well, which means that parties to proceedings will generally bear their own costs regardless of the result, which is really a measure that's been implemented to decrease litigation risk for employees in pursuing these claims, i.e. this really just reduces the barriers to entry for an employee making a claim, and that's the intention of the regime. So as mentioned just before, an employee may also make a claim following the end of their employment in relation to non-dismissal matters, such as an underpayment or breach of contract. It's not unusual at all for an employee to later assert that they have been underpaid and pursue this after their employment has ended. This could be due to errors by the employer, the employee's view that they were wrongly classified under a modern award, the failure to pay accrued annual leave on termination, and any other number of potential issues. An employee can pursue these types of claims for up to 6 years, in most circumstances. And so it is vital to remember that the end of the employment does not mean the end of pay-related disputes. And really the key lesson that we want you to take from this webinar is that there is significant risk in dismissing an employee and the considerations that lead to that decision. And there are a number of avenues for an aggrieved employee to take. And for this reason, it really can be beneficial to seek advice from a lawyer prior to making the relevant decision in relation to an employee to ensure all the necessary boxes are being ticked and risk is being mitigated as far as possible. And quite appropriately following on from that, as you can see on the next slide, you can also access an example of material that can be used in relation to addressing performance concerns with employees. An employee performance plan or performance management plan, PIP, you've probably heard of them before, but these can aid with providing procedural fairness to employees where there are performance issues to give the employee a fair chance to improve in their role, while also creating a paper trail of compliance with your obligations and being fair towards your employees. And on the next slide, you'll also see that we have another upcoming webinar on 29 September at 11 a.m. And this one's going to be in relation to understanding heads of agreement in commercial leasing. So if you'd like to join our firm for that webinar, don't hesitate to register through the link on that page.
All right, thanks very much, Joel. And I think now we'll just start the Q&A portion of the session. So thank you everyone for submitting your questions. Please continue to do so, and we'll try and get through as many as we can. Now, Joel, the first question that we've had come through is, what are your obligations in relation to termination for casual employees?
Yeah, and it is a bit of a sticky question with casuals in that when someone's a true casual, they don't actually have any expectation of ongoing shifts, and essentially a mini period of employment would be ending during each engagement. And that's been somewhat confused by the use of regular casuals under the Act, casuals becoming regular and systematic. And so you'd obviously still need to keep an eye on the contractual terms, but from a Fair Work Act perspective, there's not actually this obligation of termination in relation to casuals. So review your contractual arrangements basically, but also don't assume that your casuals do not have access to unfair dismissal, because when they do progress to being regular and systematic, they do have access to unfair dismissal, and you'd be going through a very similar process to how you'd be addressing it for any other permanent employee.
Absolutely, and obviously we're biased, but certainly one to always get some advice on if there's any doubt around whether or not your casuals are genuine casuals within the meaning of the Fair Work Act.
Absolutely.
Now, the next question that we've got that's come through, Joel, is what are the obligations for redundancy in relation to employees who are not covered by a modern award or an enterprise agreement?
So there's still the need to undertake a genuine redundancy. We're just not having to address that aspect of consultation under a modern award or enterprise agreement. But as I mentioned previously, we would still recommend that in at least short form, that process is complied with, just from a best practice perspective. And that's for two reasons. It's beneficial to the employees. They'll understand what's going on. That will reduce the risk of a dispute arising. But there's also commonly within Australia a misunderstanding of whether a modern award applies to certain employees or not. And if there's any risk that a modern award does apply, you should absolutely go through that process. So even for individuals who aren't covered by a modern award or aren't considered to be covered by a modern award, we'd still recommend a very similar process as it is best practice.
Absolutely. And similarly, along that same vein of sort of obligations on termination, generally speaking, Joel, how many written warnings would you say are typically necessary before you proceed to dismissing someone on the basis of their conduct, for example?
There is a widely held view that there is a magic number of warnings that need to be provided prior to dismissing an employee, and some people think it's a 3-strike rule, but really each circumstance needs to be viewed on its own merits. And the more important question is, do you have a policy in place to address these types of situations? And this is where this concept of 3 strikes comes from, in that a lot of employers around Australia have a performance policy that says that you need 3 written warnings in relation to, say, performance before you can be dismissed for that reason. But really, that's just a company applying its own policy, and there's no obligation to provide 3 warnings generally. It's really a matter of reviewing the individual circumstances in relation to the employee, making sure that you're not complying with any individual policy internally, and then measuring whether the performance issues, the conduct issues, really do call for termination or a warning in the circumstances. And that will be addressing it on a scale, i.e. some conduct will obviously amount to serious misconduct and the employee won't even get their notice period paid out. Lower level issues will only require a warning, but that warning should be caveated with the fact that future conduct that is similar could lead to a dismissal. And that's really how you work towards a risk-free or as risk-free as possible dismissal in relation to performance and conduct issues, is make sure prior warnings are given and that those prior warnings do address that similar issues could lead to the end of their employment.
Absolutely. So like everything in employment law, it's a bit of a grey area and really does need to be assessed on a case-by-case basis.
Exactly. And I'd really stress that, if you have a policy that says you need 3 strikes to dismiss an employee, consider whether you need to have that policy internally, because it does tie the employer's hands.
Absolutely. And in terms of, I guess, your obligations on termination, when there is a different notice period under the Fair Work Act and the employment contract, which is it that needs to be paid?
So a contract of employment can't undercut the minimum entitlements under the Fair Work Act and the National Employment Standards, but they can exceed it and have it be binding in contractual law. So if it's something that is lower and unlawful in the context of the Act provisions will obviously need to be paid. But if it's something that has been varied under the employment contract to be more beneficial to the employee, that contractual amount will need to be paid.
Absolutely. Now, another question we've had come through is kind of based around our first topic as for, whether or not the termination is at the employer or the employee's initiative. And the question is, what would abandonment of employment come under?
And that is a really good question, because this is commonly misunderstood. And abandonment is actually a concept under some modern awards that says where an employee has been absent from the workplace for a certain amount of time and the employer has tried contacting them a certain number of times, then it will be taken that the end of employment will be subject to abandonment. And that's not at the employer's initiative, but it's also not widely available in the sense that this isn't really a common law concept. And really, if an employee is abandoning their job, then you would be taking it as a resignation by their conduct. But there is still some grey area to say that where an employer is accepting that resignation by their conduct, it may still be their initiative. So the answer is abandonment is not a common concept to have to deal with, because it's only actually relevant under very certain modern awards. And you do need to address it in the scope of the conduct of the employee, rather than abandonment as a general concept where there's not an applicable award covering the employee. So it very much could be seen to still be at the employer's initiative.
And in terms of another question in relation to payment in lieu of notice, obviously another term which gets thrown around a lot when it comes to termination is gardening leave. Now, is gardening leave the same as paying an amount in lieu of working out a notice period under a contract?
It's not, and there's a very important distinction. And the reason that companies use gardening leave is normally to prevent a high-level employee's contractual restraints from commencing until the end of that notice period during which the employment's actually maintained. I.e., you're basically putting the employee on the bench and saying, you're not going to be doing any work during this period, but you are still employed by us. We're going to pay you in accordance with our normal pay cycle, but you can't go off and compete with us. And then once our period of gardening leave ends, your employment will actually end then. And the restraints within your contract will take effect from then. Whereas if you're paying in lieu of notice, you're actually ending the employment immediately, paying the employee all the amounts they're owed, including in relation to the entirety of their notice period, and the employment ends at that time.
And I guess that concept of gardening leave would probably be, probably a lot more relevant for more senior level executive employees who perhaps you don't want running off to a competitor.
Basically, paying in lieu of notice is, in a broad sense, beneficial to the employee. They don't have to work out their notice period. They're getting that chunk of money that would have been paid out to them over that period in their hand, and they can go off and find employment subject to their contractual terms. With gardening leave, it's beneficial to the company in that you're really trying to just keep someone on the bench and away from competitive companies for a certain period of time, while also making sure there can be a proper handover.
Of course. Now, another question that we've had come through is what are the considerations or the potential risks of terminating employees during probation? Obviously, we understand that there's unlikely to be any access to unfair dismissal, provided it's less than 6 or 12 months, but are there other risks that you find a lot of employers are unaware of?
With probation, it's a contractual concept, and the more important thing to keep in mind as an employer is that statutory minimum notice period we mentioned just before. And that is the notice period, or the period of time, that allows an employee access to make an unfair dismissal application, and means that we're going to have to be thinking about things like procedural fairness, providing warnings, etc. It's quite common marketplace common for a 6-month probation period to be present in an employment contract, and that normally aligns with the minimum employment period. And so don't so much think of the importance of probation as being probation itself. It's normally that it aligns with the minimum employment period and means we don't need to provide procedural fairness to the employee. But other common mistakes made around probation are that it is a period to actually assess the employee's performance. And so if there haven't been huge performance issues and you're dismissing an employee midway through their probation period for unstated reasons, it can look a bit unusual, i.e. if we're assessing the performance and there's no real issue, why were they allowed to work out their probation period and have an outcome at the end of that? So I would say think about probation in a contractual sense as to what its purpose is, i.e. assessing the performance over a certain period and ensuring you do that, but keeping in mind that the more important concept is that minimum notice period under the Fair Work Act.
Absolutely, and also the fact that even though they may not be eligible for unfair dismissal, there is no minimum employment period for an employee to bring a claim such as under the general protections provisions. And well, Joel and I frequently see people try and shoehorn some very interesting claims where they otherwise don't have access to the unfair dismissal jurisdiction.
Yeah, and that's it. You can't rely on a probationary period in a contract to keep you safe from those other claims. It's really a bit of an outdated contractual term in light of the way the minimum employment period operates in Australia, but it is good to include it in a contract just to have an employee understand in writing their performance is being assessed during this time.
Absolutely. Now, I've probably got time for a couple more questions, so we'll try and get through these. The next one is, can an employer withhold the payout of annual leave following termination or resignation?
And the answer will be almost always no, unless there is a specific modern award term that is allowing deductions in relation to that. And there are some very limited circumstances where wages can be withheld, but it's not any great quantum either. And it's normally in circumstances where the employee hasn't worked their notice period. The general rule here is just no. There's very, very extensive restrictions around deductions from wages for employees. And so always take advice on this if it is something you intend to try to do.
Absolutely. All right, final question then for the day. This last one is just in relation to redundancy. So the query is, will the redundancy still be valid if some of the tasks previously performed when the redundant role are effectively incorporated into a new, more expanded role?
It can still be an effective redundancy. And in the same way that a person isn't the job they're in, a job isn't the duties that make up the job. And so it's quite common to still need some duties to be performed, and it's completely permissible for those to be subsumed by other employees. And the relevant question is, has the job survived the redundancy, not have some duties survived it? So as long as that job doesn't exist, no one is performing that role anymore, it's not an issue that other employees have picked up some duties.
Perfect. All right, thanks very much for running through those questions. Obviously, if there are any further questions after the webinar, feel free to reach out. But now I'll hand over to Joel to wrap things up.
Okay, thank you, Sophie. And you can see on that slide currently our firm's offering. And under our LVC Pro package, our clients pay a very reasonable monthly fee that then covers all their business as usual legal needs. And this includes all the areas a commercial law firm covers and would advise in generally, including corporate and commercial, intellectual property, corporate immigration, and of course, employment, which is the team we're from. And so to give you an idea of what this would cover in relation to employment law, this would include things like the unlimited drafting of employment agreements and other employment documentation, independent contractor agreements, legal policies, and then also advising on all employment-related matters, including performance management and dismissal, and also redundancy, which we know is a big query popping up quite regularly right now. And beyond that subscription service, we can also act for clients in relation to any employment dispute within a provided extras fund as part of that package, or for very reasonable hourly rates outside of the description. And really, this service represents great value for all our members, especially compared to the typical cost of retaining commercial lawyers. And we really strongly consider you joining our firm. And as you can see on the next slide, to assist with an understanding of what our firm can offer, all attendees today can request a complimentary consultation to discuss how we can help. Just follow those instructions on the screen to arrange that. So thank you everyone for attending, and we hope that you have learned something today, and otherwise have a great day, and don't forget to join us in our future webinars. Thank you,
Thanks,
everyone.
everyone.